coming to our weekly parliamentary press briefing for the Office of the Leader of the Opposition. Today, the Leader of the Opposition will not be with us, but we do have a number of issues to raise relating to Parliament and some follow-up issues from the last press conference we had. First of all, you will recall that the Office of the Prime Minister a few weeks ago criticised the parliamentary opposition for not attending the Parliamentary Management Committee and other committees. And we responded in an official press statement correcting the Prime Minister's allegations. However, not all the media covered that. However, the media may be interested to know that the last PMC meeting on April the 13th was postponed due to the unavailability of all the government members. Despite the long period between the sittings as a result of the 54-day break, and I'm asking the media to please not call it a recess. It is not a recess. Recess is August the 10th to October the 10th. This is an unscheduled pause of 54 days. But in this period, which one would have thought would have been used as an opportunity to get a lot of the committees functioning and meeting and so forth, this has not happened. And in particular, we highlight once again that the Constitutional Reform Committee headed by the Attorney General, nor the Parliamentary Standing Committee to oversight the security sector have been convened yet again in this period. So since they were appointed last year, there's not one meeting that's been called by these chairpersons. And I take note that these are two critical areas. One, with regard to a steering committee that is putting forward recommendations for constitutional reforms, yet the parliamentary body, which has constitutional mandates, has no role whatsoever in all of this. And secondly, due to the state of the security sector, not only the prison but the crime situation in nationally, that this committee, also headed by the Minister of Public Security, Mr. Ramjatan, has also not been convened. The refusal of the government to use these parliamentary mechanisms, and in fact, by doing so, its denial to use these mechanisms, which provide for greater inclusivity and participation with the parliamentary opposition and civil society. We've opposed the presence of ministers on the 4 oversight committees and the Public Accounts Committee, as you well know, as this is a conflict of interest and an undermining of the constitutional provisions and intent for such committees to oversight government policy and performance. Our principal opposition to this has been supported by the recently concluded 2 training programs by the Commonwealth Parliamentary Association. In addition, we knew that ministers would have difficulties attending these committees, and so said, so done. The Parliamentary Sectoral Committee on Social Services was aborted on Friday last due to the absence of the government side made up of ministers, and even the chairman, who was a government MP, turned up and asked to be excused, and the meeting was aborted because he had another appointment. The Committee of Appointment, the Parliamentary Sectoral Committee for Foreign Services, the Parliamentary Committee for Natural Resources, and the Public Accounts Committee are probably the only 4 committees that are functioning. Please note, 3 are headed by opposition MPs, and that may explain why they're meeting. The Committee of Appointment is addressing the applications for the FIU, Director, Deputy Director, Accountant, and Lawyer, as provided for in the amended Anti-Money Laundering Act of 2015. It is also commencing consultations with the civil society for nominations to the Anti-Money Laundering and Countering the Financing of Terrorism Authority, again in compliance with the 2015 amendment of the Money Laundering Act. The Committee of Appointment is also dealing with the nominees to the Ethnic Relations Commission and the local government nominee as provided for in the Local Government Commission Act that must come from the Parliamentary Committee. That has been completed and that should be tabled at the May 4th sitting. However, it is noted that the government side seems to be uncertain as to who approaches the President and the Leader of the Opposition for their appointees in accordance with the Local Government Commission Act. In every parliament, there is acknowledgement that the work of parliament takes place in the committees, and this forms the backbone of the functioning of an effective legislature. I met with the Speaker at his invitation on April the 14th and encouraged him to ensure that the critical non-functioning committees were meeting and to use whatever influence he could on these busy ministers to make sure that these bodies are functioning, and that even encouraged him that some of the committees he chairs, which are also have not met, such as the Statutory Instrument Committee and the Assembly Committee, be operationalized in the best interests of the legislature. On the May 4th agenda, one is hearing from the Office of the Prime Minister about a number of pieces of legislation heading for the May 4th sitting. From the list being presented to the public, in our opinion, all were required to be sent to parliamentary special select committees. In fact, I wish to inform the media that I have been approached by the Government Chief Whip to ask if we would support the amendments to the Anti-Money Laundering and Countering the Financing of Terrorism amendment bill, if we would support it going through all three stages at the one sitting on May the 4th. Our answer was a resounding no. We would not support bills going through all three stages at one sitting. No one is aware of what these amendments are. It is April the 20th. We don't know what these amendments are to the money laundering bill, and therefore we will not be accepting these amendments, these fresh amendments coming through on one day, May the 4th. And we've encouraged the Chief Whip of the government that we could meet again the following week to go through this and go through second and third stages, even though in principle we feel again that these large and complex amendments should go to parliamentary select committees. Furthermore, when I asked the Chief Whip what was the rush, I was advised that they were rushing to prepare for FATF. I asked, when is the FATF meeting and what were the deadlines? The Chief Whip in the government side could not enlighten me. Guyana is slipping on its commitments to FATF as it has no FIU director or deputy director in place, no anti-money laundering and countering the financing of terrorism authority in place. The FIU is headless, and therefore many aspects of the Anti-Money Laundering and Countering the Financing of Terrorism Act cannot be put into operation, and if it is, it would be in violation of the law. It is regrettable that the speed with which the government wishes to go on the floor of the House to take this bill through all three stages is not being replicated in the Committee of Appointment, where the matter of these appointments are being addressed. We shall see if the government on May the 4th, proceeds to take the AML-CFT amendment bill through all three stages, despite the opposition of the parliamentary opposition. We want to go on record as saying that we're anxious for the whistleblower and witness protection bills to be brought to the House soonest so they can be subjected to scrutiny enhancement at the Parliamentary Special Select Committee level. The whistleblower legislation is badly needed as protection needs to be provided for those who will expose wrongdoings in the public and even the private sector. The model we support as a party is captured in the OAS, Inter-American Convention Against Corruption, MESICIC group, which completed the guidelines for countries bringing such legislations in 2013, after 3 years of consultation with the countries of the Americas. We're in support of those guidelines, and therefore from then on, when we received those in 2013, the Chief Parliamentary Council and the drafting unit of the Ministry of Legal Affairs was asked to study it and start preparing the draft. The draft we've seen published on the Attorney General, the President Attorney General's website, does not reflect some of those recommendations of the OAS. However, we feel that this piece of legislation is critical and be willing to have it enhanced, strengthened, and supported. But we urge the government to bring this in as quickly as possible. Code of conduct for ministers and MPs. Again, from the media, the parliamentary opposition, and I must pause here to say thank you to the media, because in many cases we find out what's going on through the media and not through official relations or engagements with government agencies and the government ministries. As I said, again from the media, the parliamentary opposition is informed of a draft code of conduct for the ministers and members of parliament. We've not received a copy of it from the Office of the Prime Minister or any other minister of government or any other agency, and yet they're supposed to have some consultations. but 32 members of Parliament of the opposition have been deliberately alienated from the development or design or drafting or consultation on this code, which it appears at some point will be imposed on all. There is nothing wrong with the government having a code of conduct for its ministers and MPs. The People's Progressive Party had one of its own for its own elected officials, ranging from local government bodies to the executive, which is still in operation. However, once this is broadened to include all MPs of both sides of the House, then it goes without saying that 32 of the 65 stakeholders must have a say on what it will contain, and this too should go to a parliamentary special select committee. At the last parliamentary briefing on the 14th, I pointed out a case of a head of an agency, unnamed, both head and agency unnamed, which was involved in soliciting donations for certain projects in that sector. For the record, I wish to reiterate what I said then. That's why it's important when I come to these meetings, I bring my notes. This is what I said. Extortion of contractors. The head of one agency with a minister convened a meeting of the contractors in that sector in the week before Easter to seek donations of 12 million to carry out works. The message was clear: if they didn't donate, they would be unsuccessful in the future with being awarded contracts. The meeting succeeded in raising $8 million. Yet this agency has money in its budget to carry out these works. The budget was passed less than a month before, and therefore there was no shortage of monies to carry out these works. In fact, monies have been allocated to do work such as these identified. And then I went on to talk about businessmen are facing pressures to donate to the governing party and or whatever pet project is in the making, and have been called directly requesting donations with the threat of not getting work and contracts. This is occurring in service and the contracting sectors. I went on to talk about sweetheart deals and so on. That's what I said. I have noticed that a head of agency has come out responding to me and denouncing that there is no problem with soliciting donations. I repeat, I never named the agency and I never named the head of the agency. And so what I say, as Bob Marley says, who the cap fits, let him wear it. You know, but he did, having admitted that he did solicit donations. The issue must be answered. And our bottom line is that no head of an agency, no minister, should be soliciting donations from anyone. That's the bottom line. Implicit or explicit, there's always the impression given to the person who is being called to ask to donate, especially when a minister or head of agency is doing it, that this will enhance or could harm your possibilities of getting work with the government. Last week also, we talked about the National Grade 6 assessment. And we noted that the Ministry of Education put out a statement. However, this issue still stays alive. We are advised as of Friday that a number of the rural and interior schools had still not been in receipt of documentation that is required for the teachers to prepare the children with mock exams and the format and so on to help them prepare for the exams on the 27th of April. There are complaints by children that have written the mock exams that the exams are different from what the kids have been taught in school over the last year. Whether these are true or not, or whether there is maybe an exaggeration, the point is that the NGSA, as with the Common Entrance, is one of the most stressful times for children at the age of 11 in our country. And to put additional stress on them by late notices, change of format, and worse yet, and I hope to God not, change of syllabus, is absolutely unconscionable to do this to our children. And I think it is almost 60,000 children or 50,000 children who are under this duress, because it appears to be in our country that a child's life is determined at the age of 11 on the basis of whether they do well at NGSA or at Common Entrance. Their entire life is determined by that. And so it's regrettable that despite Mrs. Priya Manikchand raising this almost a month ago now to do with NGSA and exposing the fact that the syllabus, there were changes The Ministry of Education has been crawling to deal with this issue. And therefore, we find this ineptitude, inefficiency, and hopefully not sinister move and behavior of the Ministry of Education extremely, extremely disturbing. And we wish, as the children will be writing on the 27th, that we wish all our children writing the Common Entrance, or what is called the National Grade 6 Assessment, the best, that we know they've worked hard, and that do not be distracted, and to do the very best that they can. But that we find this behavior of the Ministry of Education unacceptable and unconscionable with regard to 50-odd thousand children in a matter of days. Thank you. Any other issues? Any questions? The floor is open. Yes. Yes, Adam.
You were talking about the anti-money laundering bill.
Yes.
And we know that this has been languishing in Parliament and modifications and all of that. Exactly what is the government's position as it relates to the, the opposition's position?
Well, let me just remind you that the bill that was defeated once in the last Parliament and then held at ransom in the second part of the same Parliament was brought in June by the government, June 2015, and the government passed it. So the amended anti-money laundering bill, with the amendments that the then opposition was insisting should be included in the bill, was brought in July, I think assented by His Excellency President Granger in July 2015. So that bill, with the provision of the FIU being appointed through a process with Parliament, the FIU staff, the new authority being created, is all parliamentary work. That's in the Act, as assented to by His Excellency. In addition to that, the Minister then brought further amendments sometime, I think, now I might be forgetting the exact date, but before the year ended, which again they tried to rush through the Parliament in 3 stages on one day. And then in addition to that, there were several regulations that were also brought in between. So that this is now a new set. This is a completely new set of amendments. We are not aware of that. We know that the Attorney General called a meeting, I think, about 3 weeks ago in his chambers with a number of people to consult on the bill. The question raised by our representative, who was Mr. Nanda Lal, was that could we see what are the FATF recommendations to know in what way are we in compliance? These amendments bring us into further compliance. In what way are these new demands of FATF that we have to comply with? That was never provided, nor do we have a copy of the bill provided for by the Attorney General to the opposition party and to the leading opposition. So that we have no idea if after the consultation that the Attorney General had about 3 weeks ago, whether he has further amended the bill. We have no idea. So we have no idea what it's going to look like when I raise it with the Chief Whip, that we don't even know what this bill is like. Is it, well, it'll be gazetted and circulated before the May the 4th. And I said, isn't it possible to have a preliminary look at it, if this is what is approved by the Cabinet? This didn't seem to be in the realm of possibilities. So we are going in blind. These are major pieces of legislation. And so these are completely new amendments. We don't know, and Adam, that there have been some amendments. The 2009 bill was amended by 2015. There have been regs made in 2010, regulations made in 2010. There have been more regulations made, I think, in 2011. There are regulations that have been made in 2015. There have been amendments, huge amendments in 2015 coming out of the earlier parliamentary process. So when you get now a bill with further amendments, you've got to go back to the principle and you've got to do comparison, because all these things have not been consolidated into the actual act. It's all in pieces. And so this takes time to ensure that there's not a contradiction, there's some coordination, that there's some consistency. This takes time, and if we get it, and we have holidays in that period too. You got May the 1st, the holiday is a Monday. You have Arrival Day, which is the day after. When do we get these bills to be able to have the proper examination? Even if we go through just the first reading, as an opposition, we're entitled to and required to go through these things in detail to represent the issues properly. And so we're very disheartened by this move. I appreciate the Chief Whip having the decency to call me and to say she was instructed to contact me to get my view on this. So I appreciate that, and not being caught in surprise on May the 4th. So I appreciate that overture. However, I have no idea if the overture will lead to any change in what is the intention of going through 3 stages at one sitting. Any other questions? Questions?
Perhaps we can talk about the people you have, whether you're looking at in relation to the appointments to these committees related to the whole anti-money laundering.
Yeah, FIU and AML-CFT Authority, yeah.
How many names do you have before you?
We did an advertisement for the FIU, director, deputy director, lawyer, and accountant. I don't want to give a figure that's wrong, but we had quite a sizable number of applicants for director, deputy director. Probably the smallest number of applicants were for the lawyer. We met last week and decided that a subcommittee would now develop the criteria, what you call this, the weighting, the scoring system. And we are meeting back on the 27th, this week coming, to start looking at the score sheet, the score system that has been drafted, and then to start looking at the applicants. From that, then we will shortlist and then call people in for interviews. However, we have in the advertisement and even in our own discussions and in the letters that went out, even to the NGOs who are being invited to give nominees for the authority now, that's a different group, the 10 names that have to come on the authority. We have quoted extensively, we are quoting extensively from the definition of politically exposed persons. Because as you know, both in FATF definition and the definition in our Anti-Money Laundering and Countering the Financing of Terrorism Act, as amended in 2015, is that politically exposed persons, it's a very large group, not only persons in government and ministers and discipline forces and police and law enforcement and permanent secretaries, but also close relatives and associates of, living here or overseas. And so we've had to say that the interviews we do, we will have to advise persons coming before us, for these are the positions in FIU, that we will have to ask questions that normally would not be asked in a job interview. Who are your relatives? Where are they living? What are they involved with? These are questions we have to ask now because of the act itself. And so some people need to know that, and we've said to them, look, we will be delving in, and this is what we have to do. Whereas in a normal job application, if people start asking you, what your cousin and your brother and your sister and your wife does, that's none of their business. But this is now a different issue. So in the FIU, that's the process we've agreed on, and with the authority, letters will be going out to what we've agreed to, a list of organizations. We've agreed on a list of NGOs that are relevant to money laundering, in which they're being asked to provide 1 or 2 nominees. They're encouraged to even put more, because we recognize we have to go through this due diligence process. And in the letters that will be going out, we'll again advise them on the PEPs, I never say it right, but politically exposed persons, and so forth. So there's, at least I can say in the Committee of Appointment, there is some steady but slow, unfortunately, but slow and steady, if that's the correct way to put it, of some movement on that. And as I said, we've completed the nominee for the Local Government Commission. We've completed, and that should hopefully go to Parliament for its approval on May the 4th. But the chairperson of that is Dr. Norton, so he calls the shots on those issues, not me. Any other questions? Yes. Sorry, I didn't hear you, love. Could you repeat?
I was hoping to get Dr. Jagdeo to respond to this, but yesterday we got the announcement that we will be hosting and hosting the final CPL. In the opposition's opinion, good investment or no?
I'll leave that for him to discuss. We're just receiving the invitation ourselves. We need to examine it. I wouldn't give a knee-jerk reaction at this point. We made very clear in Parliament that we are not here as obstructionists. We're here for the development of our country, and we will support activities for the development of our country. But we will expose those that harm our country.
But did you also hear that Guyana was going to put some $5 million to this bill or something sort?
To which bill?
The CPL business hosting the semi-final tournament.
I have no idea. That's recent?
I heard that yesterday. I don't know.
That's an awful lot of money, isn't it? I leave it to you, the journalists, to do your good investigative work. But no, I've never heard of that. I don't know about that.
Mr. Chair, if I can ask a quick question. You mentioned that the Attorney General had consultations at his chambers, but the opposition has criticized that kind of movement
Yes.
past
Yes.
as given that, that is being used to bypass the select committee. Given
Yes.
that it's the same thing with the AML amendments, how optimistic are you that it will go to select committee?
I don't think they will. I think that they may concede that it has to can't go through 3 sittings, but I believe that they seem to be terrified of parliamentary select committees. It's unimaginable that in 1 year, we're almost meeting 1 year, June the 10th, I think, will be 1 year that this Parliament's life began, and there has been 1 parliamentary select committee appointed, not 1. And in fact, if we trace the earlier parliaments, the last parliament went along a similar vein as this in terms of some parliamentary select committees. But previous to that, there were parliamentary select committees were where the children's legislation, 6 children's legislation came out, the financial regulations and laws, health laws, and even going back to the very beginning, domestic violence and medical termination of pregnancy. All these things went through. There's so many laws in terms of even the judicial service reform, the Court of Appeal Act, and all these things all went through select committees. And so I think in the 9th Parliament, there were 140 bills, of which probably 40-something alone went through special select committees. And in that 140 would include bills like the appropriation bills, your supplementary financial bills, which are procedurally, guarded and guided on what they do. So the Minister of Legal Affairs seems to prefer his chambers, the safety and security of his chambers, to hold a consultation. He has had 1 on this bill as far as we know. I'm not aware if he's had any on cybercrime, which I hear that's been talked about, or insurance, or on whistleblower, or on witness protection. I'm not aware of that. But the consultation of a minister sitting in his chambers with a few chaps sitting around does not replace, and should not replace, 1, the consultations with civil society, and a consultation process mechanism provided for in Parliament through the Parliamentary Special Select Committee. It could be added to, could be additional to, but it cannot supplement. It cannot become an excuse for not having a gathering. And the reason he may prefer the security of his chambers is that when they have had 1 or 2 consultations at the convention center, and organizations put up amendments, I think it was the anti-terrorism, human rights body, the private sector, to do with the financial institutions amendment bill and so on, that these were all shot down. They were never included, and therefore maybe prefers the sanctity of his office so that there can be no public disclosure of what some of the organizations have asked for or represented or recommended.
Also, Norway delegation is expected next week.
Yes.
Can you say what plans the opposition has for probably engaging them?
Well, we haven't been officially informed, but I'm pretty sure they will be engaging, except the leader opposition would not be in Guyana, as he will be traveling overseas. He's been invited as a special guest and panelist for the high-level ACP-EU, what's called ACP-EU high-level event in Dakar, Senegal, where it's a high-level body, and he's invited as co-chairperson of the Eminent Persons Group, leader opposition and former president, to attend this, where the high-level meeting of will be looking at the future of ACP-EU relations. So he will not be here when they are visiting. However, other mechanisms are putting in place to make sure that we are able to engage with the Norwegians, in addition to other activities we have in relation to our representation we made a few months ago during the budget in relation to statements made by Minister Trotman on the forestry concessions. We will be continuing our engagement with the Norwegians on some of those issues. Nothing else? Short and sweet? I notice Adam isn't asking me about the statement by the member of the agency.
By Richard Van
You said it.
No, I got it him. I mean, I talked to you, and you said you didn't call no job refused or something.
The question is that you must ask, my dear Mr. Adam Harris, is that first of all, where did they, when the donations were received, did the money go into the Consol Fund, or did it go to the ministry's project, to the Gaiwa financial sector? Did people receive receipts? And so forth. But the fundamental issues are these, Mr. Harris. One, a $230 billion budget was passed a month before. 195 million is in the capital works for Hinterland Water. Why, within less than a month, you are asking for donations of $12 million for that particular area which the capital works provide for? I've been long enough in government that if there is an emergency, that the ministry, the head of agency or the PS, can request to finance environment or waiver in the program to allow for an emergency or immediate response if the wells are an issue in Region 9, because this is what it is. There are 9 wells that they're now doing it. And by the way, the Brazilian army has been contracted to assist with the feasibility, and they've also hired 17 contractors in the region. So that what is unusual about this is the fact that $195 million is there. There's a drought situation. You have Mr. Joe Singh, who's heading the National Task Force on Drought Relief or whatever, who seems to be excluded from this operation. And so that's one issue. This is what is irregular about it. The second issue, as a principle, the head of agency or minister should not be calling, particularly contractors, to them and saying, look, we got a project at 12 million and we'd appreciate your support. And I know, and I do not want to put any of the persons present at that meeting or who were subsequently phoned by the same gentleman. And certainly, you know, if you are not going to contribute, same thing with Durban Park, if you don't contribute, 140 businessmen were called to give money to Durban Park. And if you don't give, obviously the implication is there that, if you don't abide, you don't behave a good boy, you don't, contribute, then you will not be on the list of priorities, or you may not get considered. And every contractor in this country, every businessman in this country is saying that. It's not Gail Teixeira's fiction or the PPP's fiction. They all know the message is clear. And so, if it was an emergency, you and I know, we've been around long enough. We had the cholera epidemic in October 1992. We had just got into office on October the 13th. The first cholera case was October the 31st. Ministry of Education, Ministry of Health budget was 220 million for the entire country. We didn't have money, we didn't have a budget even. We were using the budget left over from the regime that stepped down. And so we put out calls for donations of antibiotics, of water, of fluoride tablets, of buckets, and so on, and there was a whole mechanism put in place. We didn't have CDC in those days to put in, and so letters and thank yous and so. It was an emergency. You want to stop an epidemic. But you're telling me you have to ask private people for $12 million when you have $195 million in your budget for hinterland water? And that you can't go to cabinet, because we know as cabinet ministers and as members of cabinet, ministers are always running to cabinet. Some machine broke, something happened, unforeseen that may not have been in the budget, and you're asking for supplementaries or for waivers and so on. Cabinet has that capacity to do it. Hold your requests in the case of an emergency, a disaster, some tragedy, something important. Maybe if they've done that to help bury the 17 prisoners who were murdered and burnt to death, that could be understandable.
Murdered?
Well, somebody did. As I said, I don't know who.